or dismissing.
Okay, so we talk about judgment in default of defense, regularly obtained and irregularly obtained. Remember that? Yes, can you tell us or remind us what the distinction really is? And your friend is missing today. Okay. And then the other lady too. There's another one who sits here. Okay. Last time you two were missing. Yes. You were black and white. You're burying your head. What's the name? Madeline. Yes, Madeline. Last class, you're not here. Begin. I know your faces, so now if you're absent, I can see you. So, how my friend? And you call him, was it their name or who? What's the name? Prince Charles. When he was absent, I will tell it. Yes. The backbenchers. Don't think you can skip my view. Okay, so we would like to discuss striking out. So I think maybe before we do striking out, because striking out applies to statement of claim, other pleadings, and also counterclaim. Maybe let's discuss the counterclaim first, and then we will discuss other Levy Rule 18. Then we move on to maybe other 16 amendment. So, counterclaim. What is a counterclaim? So, yes. Yes. All right.
It has to do with pleading of point of law.
Pleading of point of law, okay.
Pleading of law. And Lord, you made us understand that we don't specifically plead law, but we couch our pleading in such a way that it falls on.
We'll not use the mic. Is the mic around so that, yes.
Thank you.
So, but before he talks about the rules on the pleading, can you tell us the difference between pleading law and then point of law? Not only him, anybody. Yes.
Okay, by the way.
I mean, pleading law, for example, if you are doing something like a claim, which is, for example, founded on a particular statute. Let's assume that maybe you are doing, probably there's a legislation on a particular thing and your claim is mainly grounded on it or something like that. So in that case, you plead, it's not requirement. It's not requirement to plead, you set up, but then depend, you see, the thing about pleadings is that we have the general principles, but how they actually work out in practice, we cannot exhaust all the scenarios. And that is why, let's say that in a unique configuration of facts, it may not be out of place for a plaintiff, even catching his relief, to even base it upon a particular statute, as it were. So, for example, let me give you an example. let's suppose that we have a legislation which was passed to deal with, let's say that where the gas explosion occurred, what's the name? People died, some very sad incident. Appear or something, yes. So let's assume that the government, parliament decided that no, let's pass a legislation to particularly to address victims of that particular incident. And let's assume that you fall within the class of the what's supposed to benefit. You've made the necessary requests to the particular department or government agencies in charge. And they are, for example, not doing what you are supposed to get under the law. If you frame your relief, it will not be out of place. If, for example, you link it directly to that particular legislation, because that is where your rights or your interest is coming from. So there'll be nothing wrong with that. But we are talking about maybe general things, your pleadings, plead relevant provision of the Courts Act, relevant provision of this, like just a general, those are what is not required. But if you are talking about maybe like a point of law, for example, like maybe like the matter in statute ban, or maybe contributory negligence, estoppel, res judicata, they are all points of what? They are all points of law. So that is the difference. Yeah, so let's take the pleading aspect. Yeah.
My Lord, it's like you are a prophet as well. Because
please, it's dangerous to be a prophet in Ghana. I think if I love God, I love worship. But if there's one thing I don't aspire towards to be in Ghana, no, I don't like the prophetic ministry. No, I think prayer and the word ministry, they are enough. Yes, I don't want the prophetic ministry. Because I don't want a situation whereby you do things, you prophesy and you say, okay, and the Spirit took me into the realm and I saw this, but it's not confirmed yet. It's yet to be confirmed. I don't like that prophecy. Or after certain events, I come and apologize that I shouldn't have prophesied. So I'm going to do something. No. I don't want to do that. Yes, please go ahead.
Hello.
Yes.
Yeah. So please, my question was a comparison between two cases.
Okay.
And you address it in a way.
Okay.
Because when you read the case of Abeka and Son,
yes,
Abeka and Son explain point of law to mean that you don't necessarily have to plead, let's say, a particular section.
Yes, the provision of an enactment.
So Abeka and Son is to the effect that you don't necessarily have to plead specific provision of a statute to succeed in
the course of action.
Exactly. However, in the case of Daho and Imadi, in fact, PIJ made a profound statement, and my Lord, with your permission,
you could.
I want to read.
Yes, please do. No, he's practicing law already. Yeah. Already talk about in the courtroom. Yes, counsel, proceed.
My Lord, says the general rule of law. The general rule is that law as such need not to be pleaded. This principle does not relieve a party who seeks to rely on a statute to defeat an action of the duty to plead its property. So if a party seeks to rely on a statute
as the main foundation
to defeat an action, that party must plead that particular statute properly, and not just by saying the Rent Act. he went on to say that you have to specifically state which part of the Rent Act the person has violated.
Yeah, that is true. But that point, you see, that's the thing about the case law regarding pleadings and some of those things. Oftentimes, they are not cast in stone, and they are amenable to various judicial interpretation. So you can get a judge who will write and say that, yes, you don't need to specify the particular provision. In any case, when we talk about interpretation of a statute, the whole act is supposed to be read as what? As a whole. So if you are saying that the particular claim you are making, for example, is not maintainable because of the Rent Act 19 what? Act 220. 1960 what? 1963,
Yes.
Act 220. Assuming that is an example. That the failure, let's say that to bring out a particular provision per se should not defeat the merits if during the trial you be able to bring out the necessary evidence so that during the address you can make your point. And that is why I said that when it comes to pleadings and how the authorities are, we see a lot of vacillation here and there. That is one point you have to know. And that is why I always want us to start from the statute. So let's start from the statute itself. And then after the statute, there are a lot of case law. Each of the principles that we're doing, we can get not less than 20, 30 cases for each of them. But almost all of them, they keep rehashing the same point. So you know the statute, the provision, and then read as many of the authorities as you can. And then know that at least you have idea of how the provision works in fact. Yes, but then keep an open mind that the principle of distinguishing or stare decisis, distinguishing, you remember that. How you can distinguish one case from what? From another. And say that despite the fact that this looks like that, but due to this, you do not think that an otherwise binding precedent is what? Is applicable to the case on hand. So all those things come into play. Good. Yes.
So my lord.
Yes.
I just want to add a few something small. He said that the statute. Sorry. So he said according to the rules.
Yes.
It requires that statute be pleaded with sufficient particularity to give fair notice to the opposing party
and avoid surprise.
And to avoid surprise. So it's like that was his position with regards to the reason why maybe the person should specifically state so that the other party can equally respond, as opposed to the general rule to the effect that you don't necessarily have to plead it specifically. As was said by Atta in Okine.
Okay. Now see, just imagine if somebody put up a defense in the statement of the defense and said that the plaintiff's claim is not maintainable because it's against the laws of Ghana. That is absolutely odd, isn't it? I mean, if you say the laws of Ghana, you know how many they are. Both the constitution, the statute, the case law, customary law, and all that. So which of them? So we have to spend time fishing through which of the laws of, and that is the wisdom behind the insistence that there's a need for particularization. Or if you just say that you go to Supreme Court and say that the particular thing or mission is against the letter and spirit of the Constitution. Just that. So if you take almost the 300 provisions of the Constitution, which of them are you complaining about? And that is the basis for that kind of reasoning. Yes. But as you have seen, if maybe your defense is maybe about the frustration or your defense is about misrepresentation, fraud, and so on, you need to set up the the particulars, isn't it? Before you'll be deemed to have made a proper pleading to support the particular defense that you are trying to mount. Yeah, so let's continue with the counterclaim, and we'll be looking at the 12. So as we do, I will assume that you have read that 12, haven't you? Yeah. Okay, so we'll be reading it if you haven't read it. So a counterclaim, as the name suggests, counterclaim. The plaintiff, now after Lord Wolf reforms in UK, if you take the UK cases, which are coming after the middle of the 2000s, you will not see the word plaintiff again. So if you see most of the English cases, they've stopped using plaintiff. They talk about what? Claimant. Part of the Lord Wolf reforms, which led to significant overhaul of the civil procedure. Now, we still use the word plaintiff. There's no problem. But I'm just using that to help you to understand counterclaim. So over there, they call the plaintiff a claimant, because he is making what? The claim. And if the defendant find it necessary to also make a claim against the plaintiff or the claimant, then he is counterclaiming. So he become a counterclaimant. So the defendant make the counterclaim. So therefore, a counterclaim is a claim brought by the defendant against the plaintiff within the same action or the same case. But it is treated as an independent suit. So if you like, it's a suit within a suit, a case within what? A case, as it were. Just as if I were in a three-piece suit. A suit within what? A suit. But each of them is more or less distinct or independent. And because a counterclaim is an independent suit, there are a plethora of authorities, including the Progressive Imports and Export Shipping Limited against Muela. 1991, 1G LL 94. You have it even in your as a manual as well. Have they given you the manual?
Yes.
Yes. See, what is happening is that the cases in the manual are just representative. It doesn't mean that these are all the cases there. As I've told you, for civil procedure, if you are to be very thorough on cases, we'll not even finish a quarter of the course before the year has what? Ended. Because after all, the cases before the court, apart from criminal cases, which is just a handful, all the rest are civil procedure matters, isn't it? And every court, from even the circuit court, of course, that the circuit court is not the court for purposes of the judicial precedent. So from the High Court, Court of Appeal, Supreme Court going, we are pronouncing and playing with CI 47 every now and what? Again. So there are a lot of authorities there, but what they have in the manual is that if you will not even be aware of any case at all, you have to try and be familiar with what is there. You understand? It doesn't mean that these are the only cases. No, there are more than that. But so, for example, if a marking scheme is made and students are supposed to provide cases, in addition to any other case which you may cite, we also include this one. So that if a student is not able to cite other cases, he's also not able to cite any case from here, then there's a question mark, isn't it? That is one. But then two, if you take my head of department, that's Mr. Siedu, he holds a view, and I think legitimately so, that the students should be able to grasp understanding of the principle first. So therefore, let's say that if you know if you talk about pleadings, if you know the principles in detail, that should be an assurance of pass. And then as to whether you're going to get a certain higher, more than pass depends upon how you're able to situate it within some case law, isn't it? And some other illustration. Because like, if you know the principles well, in practice, you have the whole law report before you, isn't it? But the principle should always be in your head before it will guide you to do the research. You should know the principle that counterclaim is an independent cause of what? Action. So it can stand on its own without the primary claim. Okay, you know that. So you want to find out. You're going to look for authorities in the databases. You know what query to give to the database to bring up the cases that you have to get up. To get a writ. Or if you're going to use the index of the subject matter of the general report, you know where to go and look for it, isn't it? Good. So that's a progressive import and shipping against Mueller. The court will remind us that counterclaim stands on its own and survives even where the plaintiff's claim fails. So it is possible in a suit for the court to say that on preponderance of probabilities or balance of probabilities, the plaintiff was not able to prove his claim. So his claim is dismissed in its entirety. However, upon closer examination of the evidence, I am satisfied that the defendant has been able to prove his counterclaim on preponderance of probabilities, and for that matter, enter judgment for the defendant on his counterclaim. That can happen, isn't it? Yes. It's also possible for there to be a draw. And there was a case I dissented. I prayed they go to Supreme Court so that we know who was right or who was wrong. And I was of the view that the plaintiff did not prove his case. The plaintiff did not prove his case. And then the defendant will also not prove his counterclaim. So as you say, that is draw. Plaintiff has lost, defendant has what? Has lost. It's possible. It's possible in a case for the plaintiff to lose. At the same time, the defendant will also lose on his counterclaim. That's why the fact that they are all independent. So let's suppose that in a land action, the plaintiff is seeking declaration to a particular land. And let's assume he's not able to prove his root of title. Or he bases his declaration of title on, let's say, a land title certificate, which in the course of trial is demonstrated to be fraud with fraud. And for that matter, it is set aside. Remember cases like what? Setting aside or canceling the Brown and what? Brown and Kwashiga, isn't it? Kluge's decision. So let's say that the land certificate is actually nullified. For that matter, we cannot give you a declaration. The defendant was also making a claim to almost the same parcel of land, but he failed to prove the identity. So we are not able to grant the defendant's counterclaim. So they have both failed as it were. So let's look at Order 12 Rule 1. Look at your law. Order 12 Rule 1 of C47, Sub Rule 1 Code. A defendant who alleges that he has any claim or is entitled to any relief or remedy against a plaintiff, in an action in respect of any matter, whenever and however arising, may, instead of bringing a separate action, make a counterclaim in respect of that matter. So, two things. The counterclaim need not arise from the same transaction as the plaintiff's claim. It may arise from the same transaction, but it need not. So that if the plaintiff is looking for a recovery of purchase price for this phone, an old phone, Samsung 21 Ultra. Is sued to recover the purchase price. And the defendant also said that he is of the view that what he agreed to buy was someone with the black, they have colors, isn't it? So he was looking for black, the cover or something. But the plaintiff actually delivered, let's say, pink or silver. So he's also looking for something like some breach of a contract, but then terms of contract, conditions and warranty, isn't it? But probably that is not like a condition, or that is not a fundamental obligation. So it's not a repudiatory breach, but to entitle him to some form of what? Damages. So he too makes that claim against the plaintiff. So in the original claim or the plaintiff writ, he is seeking recovery of the purchase price of this Samsung 21 Ultra, which was sold and delivered to the defendant, which the defendant has defaulted in what? To pay him. Then the defendant will put up his defense and everything, but he also remembers that if you look at agreement, this plaintiff, they don't do it exactly as was agreed upon. The understanding was that you give me a Samsung with a black cover or casing, and he brought one with the silver. And looking at it, that is not a major obligation, so I'll not be able to treat the contract as having been discharged by breach of repudiation. But I'm entitled to get some compensation for not carrying out exactly what the contract says. So I also make a counterclaim for damages for breach of what? Of contracts. So here, you see that the counterclaim or the claim the defendant wants to make against the plaintiff is arising from the same transaction as that of what? Of the plaintiff. That is one. And that is what Order 12-1-1 is telling. But then the same Order 12-1-1 tells us that it is also permissible for the counterclaim not to arise from the same transaction. It may be something unrelated to what the plaintiff is talking about. It may well be that the plaintiff to either purchase or I entered the contract for him to sell a parcel of land to me, and he has not delivered, having made the payment. So I want a specific what? I want specific performance. Now that is not related to the phone transaction, isn't it? And that is why we're saying that the counterclaim may be entirely unrelated. The only caveat is that jurisdiction should exist. The court should have what? Jurisdiction. So all the jurisdictional rules and also the rules of venue should be what? Should be applicable. If they're applicable, it is possible for you to make a counterclaim against the plaintiff, even if it does not relate to the very transaction out of which the plaintiff is looking for a claim or relief against you. There's a case I would like us to read. John Atta Wusu against Mr. Fosuhene, or Fosuhene and Atta Wusu. And in Fosuhene against Atta Wusu 2011, 1 SCGLR 273. With respect to a counterclaim being an action on its own and so on, I think the former Chief Justice Aninia, but he was JSC then, in his concurring opinion, I think the main judgment of the court written by the current CJ Bafubode, but in Aninia was a concurring opinion. He said something which I quoted. Just listen, you can just go and read it in the case. Quote, I had a privilege of reading beforehand the opinion of my learned brother Bafo Boni JSC. I entirely agree with him that the appeal be dismissed. I am, however, adding few words of my own in support of his opinion. Then let's come to the important point. In the affidavit in support of the application for striking out the action at the High Court, the respondent herein deposed to paragraph 7 of the said affidavit as follows, quote, and I want you to pay attention to that as well, counterclaim, paragraph 6, that my counterclaim is pending before the High Court, Kumasi, presided over by Justice with repenting. 7, that with full knowledge of the pendency of my counterclaim, which is inextricably linked to the reliefs sought in the instant suit, the plaintiff has commenced another action. Then, and in the board JSS, then was continues. In my opinion, it appears the defendant has misconstrued what a counterclaim is in civil proceedings of this nature. The defendant is of the view that as far as his counterclaim is actively pending and relates to the very subject matter of the claim, the plaintiff should not be allowed to prosecute his action by a fresh writ of summons. You get the point? I think the plaintiff had a matter which had been discontinued, and later on, he decided to issue a fresh what? A fresh writ. And in respect of the matter which had been discontinued, the defendant had made a counterclaim. So when this plaintiff decided to bring like the fresh claim to try and revive the one which had been discontinued, the defendant decided to resist the action by saying that, but you can't do that. My counterclaim is still there, and it was within the case which will discontinue. So why should you be allowed to bring a fresh what? A fresh claim? And that is why his lordship was making the point that the defendant did not appear to understand the concept of counterclaim. That he would not be talking the way that he was doing. And then he referred again, and quote, continue the quotation, quote, the Supreme Court in the case of Bedema against Owusu Williams threw some light on the nature of counterclaim. And let's listen to what did the Owusu Williams teach us. Quote, a counterclaim is to all intents and purposes an action by the applicant against the respondent. It is an independent and separate word. Action. The same point will continue. Then he will cite Lord Isha in the Stumo against the Campbell, where Lord Isha made the point that, quote, for all purposes except those of execution, a claim and counterclaim are two independent what? Actions. So, on basis of that, his logic continued to observe as follows, quote, it follows that if in the course of an action in which there is a counterclaim, and the plaintiff's claim is struck out, dismissed, or discontinued, or stayed, the defendant can proceed to prosecute his counterclaim as it is independent of the original claim, even though a counterclaim has no separate suit number, different from the original suit. In practice, a counterclaim may be claimed from entirely new cause of action, unrelated to the original claim, and even against new parties who are not appearing as parties in the original action. An action in tort against the defendant who attract a counterclaim for the defendant in contract. So they will cite the learned authors of Bullen and Leak and Jacob, precedents of Pleadings. And they said at page 98 of that book, quote, in short, therefore, if the defendant has a valid cause of action of any description against a plaintiff, there is no necessity for him to bring a separate cross action, since he can make a counterclaim in the same action against the plaintiff. As the defendant's counterclaim was a separate action in law, even though the subject matter of the claim and counterclaim were the same, the plaintiff was in law at liberty to issue a fresh writ to determine his interest in the subject matter. Yeah, unquote. Yeah, so the takeaway from what his lordship said in the Fosuhene's case is that if there's a main claim by the plaintiff, the defendant has made a counterclaim, whether the counterclaim is even from the same transaction as the plaintiff. And for whatever reason, whether that plaintiff claim is discontinued, stayed, or striker, or whatever, so long as there was no bar for the plaintiff to be able to bring a fresh action, it will not be a defense for a defendant trying to resist the fresh action by the plaintiff to say that because I had a counterclaim and my counterclaim is still pending, despite the discontinuance or the striking out of your original suit, you shouldn't be allowed to bring the original suit. No. If that is the only ground, then that will fail, except there are some other grounds, so that one will be different. But if your ground is that if I had a counterclaim and your case has been discontinued, and because of that, there's no way that you should be permitted to bring anything, even if you are given liberty to come back. No, that will not actually work. So let's keep that in mind. And again, from the rendition he gave and the illustration that he gave, even if the plaintiff's claim is in tort, the defendant's counterclaim can be involved in contract. It can be in any area of the law. And that is why we said that provided the court has jurisdiction. Provided the court has jurisdiction. So let's say that when it comes to enforcement of fundamental human rights, okay, so another thing, which is we should also think about, the plaintiff has a claim against you using the traditional mode, writ of summons, in statement of claim. And you also have a claim against the plaintiff. And let's suppose that it's about violation of fundamental human rights. And then if you go into the law, violation of fundamental human rights, if you to go to the court, you have to go to where? The High Court. And it's also by ordinating motion on what? On notice, isn't it? Because it's application. So will counterclaim be applicable? Will it be applicable? Are you with me?
Yes.
Will counterclaim be applicable?
No.
Yes, let's hear you. There was an answer. I heard an answer, but I heard it through the back door when you come through the main door. Yes.
Hello, I think counterclaim may not be applicable because in such an instance, the violation is illegal. It's against the rights of the claimant. So you cannot come back again to make another claim against that person, to make a counterclaim against that person.
Oh no, what I mean is, maybe let's suppose that the plaintiff has sued you for maybe delivery up of a vehicle, what you have falsely or wrongfully detained or kept. And you also remember that, oh, this plaintiff, maybe this certain things, let's say some which can be characterized or framed as a violation of some human rights in terms of Chapter 5 of the Constitution. So, question is, in a situation like that, is it permissible for you, the defendant, to also set up your alleged violation of the plaintiff's, your alleged violation of human rights by the plaintiff? Can you set it up as a counterclaim? Yes. Right.
No,
Yes.
like the rules that we have discussed.
Yes.
You made us to understand that it can arise from the same transaction or
Unrelated or completely new.
Yes. Unrelated, but it may be subject to the jurisdiction of the court.
So in this instant case, if assuming the case is before a circuit court, which do not have jurisdiction on the counterclaim, it means the defendant cannot make it since the court do not have jurisdiction to entertain it. Thank you.
All right, thank you. Yeah, so that is one point. There's another point to support the same answer. We have authorities to the effect that where a law has prescribed a particular mode for seeking remedy or relief, it is that mode which should be what? Used. So when it comes to fundamental human rights, a particular mode has been prescribed under CI 47, isn't it? Not only CI 47, Article 33 itself. So 33, what is the order? It's order 67. Yes, so Article 33 of the Constitution, read report that 67 of CI 47, prescribe the mode that it should be by what? Application. And in terms of the 19, that should be ordinating ordinating motion on what? On notice, yes. So you have a challenge apart from the court not being the court of the jurisdiction, the mode too, because two things, a court may have a jurisdiction, but you may improperly invoke the jurisdiction. So in which case you have incompetence. The court has a jurisdiction, but the jurisdiction should properly be what? Invoked. Yes.
No, so we can take the content because I don't.
Which of them?
Regarding invoking the jurisdiction
And the court, oh, right, the jurisdictional point.
Yes.
Okay, so a court may have a jurisdiction in terms of the relevant law given its power. But then that same law or related laws might have laid down a procedure for triggering or setting the power of the jurisdiction of the court in motion. And if you don't do that, let me give you a typical example. So let's suppose that you want to prosecute somebody before the High Court. And criminal case, you issue a writ. And then you say that the plaintiff claims that one, the defendant committed offense of robbery, contrary to what? Section what? You are okay. Let's use stealing. Committed stealing, contrary to section 124. Okay, of the Criminal Offences Act. Act what? 29. Now let's look at it. There's no doubt the High Court has jurisdiction in all matters civil and criminal, isn't it? But I ask you, has that jurisdiction properly been invoked? Has it properly been invoked? No. On the same vein, even where the audio term part term has not been satisfied, the jurisdiction of the court has not properly been invoked. The court has a jurisdiction to do the particular application you brought. But if, for example, there's no evidence that has been served on the other affected party, the court cannot go ahead and exercise its jurisdiction. It's not the case that the court doesn't have, it has a jurisdiction. But for a jurisdiction to properly be deployed, to set in motion, it must properly be invoked. So that is the point. Now, another point we should note is that, of course, you may also have to read the case of the Hydrafoam Estates Ltd. Hydrafoam, I think the full one, Atta Wusu for Nyantechi Mademelen Mensa against the Hydrafoam Estates Ltd. That is 2013-2014 2 SCGLR. Or if you use the non-reported database, just look for civil number J4/62/2013. The date of the decision is 26 March 2014. And again, His Lordship, and in your board, yes, he then was to say the following quote. Another ground of appeal, which was argued by counsel for appellant, related to the dismissal of the counterclaim by the Court of Appeal. From the argument of counsel, it does appear that the reason why I'm doing this is that some of you, if in basic case, when we ask you to go and read, you wouldn't read it. And that is why I'm forcing myself to be reading some of this. Otherwise, I just mentioned the case and I expect you to go and read. If you are laughing that you not do it, it's actually shame to you. You're supposed to be reading the cases. So don't be happy that you not read it as a matter of fact. You have to read it. From the argument of counsel, it does appear that he formed the view that as the respondent has no title, the counterclaim ought to be upheld on the evidence. At common law, a defendant is not bound to counterclaim against a plaintiff, and pay attention to this. At common law, a defendant is not bound to counterclaim against a plaintiff. If a defendant puts in a counterclaim, it must be proved to the satisfaction of the court, as a counterclaim is an independent what? Action. Then he will cite the case he decided himself. In the case of Fosuhene against Atta Wusu, 2011 1 SCGLR 273, the court had the opportunity to point out the nature of a counterclaim and held that it is an entirely independent action, which for convenience of procedure will be combined in one action. In this case, as the appellant was seeking for declaration of title and other ancillary remedies in the counterclaim, basic rules of evidence require that the appellant had to prove his title to the satisfaction of the court. And then he will conclude by citing the case of Aye and Akapo against Aya Idrusu, 2010 SCGL, where he quote, this court held as follows, quote, a party who counterclaims bears the burden of proving his counterclaim on the preponderance of probabilities and will not win on that issue only because the original claim had failed. The party wins on the counterclaim on the strength of his own case and not on the weakness of his opponent's case. So as we know, Monda Binia against Amua Jebu the knife. A counterclaim is an action on its own. So the fact that the plaintiff has lost his case does not mean automatically that if the plaintiff has lost, then he has been given judgment on counterclaim. It doesn't work that way. So if you are a lawyer for a defendant, there's a counterclaim, you must pursue it with all the seriousness, vigor, and all the competence assiduously as the lawyer for the plaintiff will do. Because your counterclaim is also an action on its own, isn't it? So all the things which apply to proving your claim in maybe land title as in any case, they apply mutatis mutandis to counterclaim. And just before we look at the rules of the requirements for pleadings for counterclaim, let me remind you that we came across a certain expression when we were discussing some of the cases, that instead of the plaintiff, the defendant bringing a cross action. Did you hear that? A cross action. What is a cross action? What is a cross action? One person, take the mic and talk to me. Yes. So you have an arrangement who we should give the mic to. One particular question is asked. Okay. All right. A cross action, what is it? In one of the cases, when I was quoting the dicta, we came across that expression. What's a cross action? Yes.
Right. So it's an action by, say, the defendant, new action taken against also the
Yes. That's like a bit like remember Tin and Hoffman, law of contract, cross office. Remember that? Yeah. So the plaintiff has sued the defendant, and the defendant will also go and issue a fresh writ against the same plaintiff. This time the plaintiff now becomes what? The defendant. Now later on, there's something called the doctrine of consolidation of suits. Assuming we have a cross action like that, either at the instance of one of the parties, either the court may stay or at some point the court may consolidate, put them together as one suit. But each of them will have its distinct character so that they'll be tried together. But we come and discuss that in the course of time. So having noted that, it is worth also noting further that when it comes to counterclaim, all the things we have discussed in terms of pleadings, the rules of pleadings, they apply equally to counterclaims. So let us note that they apply equally to what? To counterclaim. So, for example, before we look at the breakdown, if you are the plaintiff, a counterclaim is served on you. You are supposed to file defense, not enter appearance, you're already in the matter. And the counterclaim will usually be part of the defense, as we'll see very soon. So instead of course, conceptually it should be part of the defense. Otherwise, it will amount to a cross action, as it were. So instead of you just filing a reply, you must also add your defense to the counterclaim. So where there's a counterclaim in the statement of defense, and it's served on the plaintiff, even if the plaintiff ordinarily will not have replied, the plaintiff will have to do a defense to the counterclaim. Otherwise, the defendant could go and apply for judgment in default of what? Or defense with respect to the counterclaim. So let's note that. And that is why Order 12.2 says, a plaintiff on whom a defendant serves a counterclaim shall, if the plaintiff intends to defend it, file a defense to the counterclaim. Sub-rule 2, where a plaintiff serves both a reply and a defense counterclaim on any defendant, the plaintiff shall include them in the same document. So just as Order 12.1.2 says that the defendant shall add a counterclaim to the defense, he doesn't need to file statement defense and then later on you go and file what? The counterclaim. One in the same document. So in practice, what happens is that you have all the things you said about statement of defense. When you finish, just before you do maybe the general traverse, remember the general traverse, or you do the general traverse, save as hearing after expressly, no, save as hearing before, because at the end, save as hearing before, expressly admitted or by necessary implication admitted, the defendant denies each and every single allegation of fact in the statement of claim, as if same have been set out in seriatim and then traverse seriatim, or set out in the stencil and traverse seriatim, as the case may be. Then when you finish, immediately you have another paragraph where you say that defendant repeats, you start from the very paragraph 1. Defendant repeats paragraph 1 to what he said, and counterclaim against the plaintiff for 1, a declaration of so and so and so, then you do that. So that is one way of doing it. Or there's nothing wrong for you to do the defense. And I will actually even encourage that so that you pay attention to pleading the counterclaim properly. Because a lot of lawyers use the shortcuts. You may sometimes run into pleading insufficiency during trial when you encounter objection here and there, because you might not have actually pay attention to your counterclaim in terms of the pleading you should set up, and all your attention was just on the plaintiff's answering the plaintiff's claim. Now, if your counterclaim emanates from the same transaction as the plaintiff, there's no problem. You could run that risk and you will be fine. But then if your counterclaim emanates from something not the same transaction as what the plaintiff claim is coming from, then it is prudent for you to be more intentional about the pleadings that you do for the counterclaim, so that you're able to set out your case well, isn't it? With respect to the counterclaim against the plaintiff. So after doing the normal defense, you can have what you call you have like a counterclaim. And then the counterclaim, you can start pleading. After setting out all the things, especially so if you think that what you have said in answering the plaintiff claim does not actually provide enough explanation of the basis of the counterclaim you are going to make, then you have to do that. And then when you finish, towards them, you say that, therefore, the defendant counterclaims against the plaintiff for so and so and so. And then you have actually provided the basis already. So that is how it is done. And if you look at Order 12.3, we are told that without prejudice to general application of Order 11 governs pleadings as we'll be discussing, to a counterclaim and defense to counterclaim or any provision of it which applies to either of those pleadings specifically, Rule 1 of this order shall apply to a counterclaim as if it were a statement of claim and the defendant making it a plaintiff. So look at it. With respect to the counterclaim, when it gets there, you don't just change the language and call you, the defendant, as the plaintiff. You're a counterclaimant, as it were, you are the defendant. You made the code. But in terms of how the rules are applied, especially the rules relating to pleadings, which you saw under Order 11, statement of claim and so on. So all the things which apply to statement of claim, mutatis mutandis, are applicable to what? To you, the defendant, in setting up the basis of your counterclaim. That is the point I'm making. In the same vein, where the plaintiff is making a defense to the counterclaim, despite the fact that he is a plaintiff, with respect to the defense to the counterclaim, you will have to be governed by rules which govern statement of what? Defense under Order 11 with the necessary modification. So let's keep that in mind. And for that matter, a counterclaim must plead material facts, must avoid pleading evidence or law, isn't it? Must contain particulars where required, for example, fraud or negligence. And then it must disclose a reasonable cause of what? Action. So if it is defective, it can be strike out under Order 11, just like how any of the pleadings will strike out under Order 11, as it were. So if you read Mr. Kwame Tete's work, he will tell us about the importance or some of the strategic considerations why you may have to do a counterclaim. One, the fact that it promotes some kind of like procedural economy. Just imagine if you didn't do counterclaim and you go and file other writs, the same party that you are in court with. It may well be that it may never be put before the same judge. For example, if you file a cross action, let's say in Accra, the plaintiff has sued me, the case at the court complex, where the high courts are. And I also decide to issue another writ. I may even issue it in the circuit court. The same party, so why do you put yourself through the hassle when you could have just brought everything in one word, in one case? Of course, it also avoid multiplicity of what? Suits. And then it ensures comprehensive resolution of disputes. But if don't counterclaim for, so he cautions that you don't have to counterclaim for counterclaiming sake. As somebody said that don't face it if it's not what? If it's not broken. So don't think that, oh, just because we are told about counterclaim, then as soon as I finish, I'm also going to make what? The counterclaim. Now, if you have a weak counterclaim, it will increase your cost exposure. If you lose on your counterclaim, a cost will be awarded what? Against you. So you can be saddled with two costs. The plaintiff wins the case. You pay him cost. Your counterclaim is lost. You pay cost for dragging the plaintiff on to court in respect of your counterclaim. So you don't have to set up a counterclaim if it's not really necessary. And again, it may also distract you from a solid defense. When it comes to land cases, for example, if you are not very sure about your title, it is not wise to counterclaim. If you counterclaim, you put your title in the contest. You have to now prove it, isn't it? But if you didn't counterclaim, it's a plaintiff who is seeking the declaration of title. You try and do all that you can to resist it. And then the plaintiff may not succeed. But the fact that it's not succeeded doesn't mean that we've confirmed your title. But then you've also not lost any title, isn't it? And as between you and the plaintiff or his successors in title, nobody can bring any title challenge to you again, except other people, because the principles of res judicata will work in your favor, isn't it? And particularly so, if you're in possession, it's not wise to make a counterclaim. Because if you're able to put up a solid defense and plaintiff should lose, you are still in possession anyway, isn't it? Except where the right person come up to challenge you. But as between the plaintiff and the successors in titles and all that, they cannot come after you. Yes.
Well, that there's a gap here because if we agree that counterclaim is a cross action,
Yes.
that is actually separate from the actual proceedings.
It's not a cross action, but it's an action within an action. A cross action would mean independent writ, yes. No, but do you understand what I'm saying?
Yeah, and the argument I was trying to
Yes.
that if we agree that it's even a cross action,
Yes.
that is going to be a separate activity technically on a different proceedings altogether. Why is it that, like you are saying, that if you counterclaim and you are not able to achieve your aim, you rather be awarded costs?
Oh, good. If you look at the 74 and then the established common law, cost follows the event. What is the point about cost? Cost is there to discipline the use of the court processes. If you don't have a legitimate claim against someone, because mind you, if you issue a writ against me, I must come and defend. If I don't come and judgment is entered against you, I'll be in trouble, isn't it? So just imagine I have to engage lawyers, or even if I acted by myself, I have to stop my work, travel to court and do everything, all to try and resist your claim. And if at the end of the day, the court comes to the conclusion that after all, you, the plaintiff, you didn't have any case maintainable against me. You wasted my time. You know opportunity cost in economics, isn't it? Other things you could have done with all the time and the energy that you use in court, they are all gone, isn't it? So if you look at the 74, we come and discuss court. If you look at the 74, the factors which assist the court in making a determination as to award of costs, all those things will come in. So please, just read order 74. We'll come and discuss cost later on, but okay, so briefly, let's say 2 sentences about reply, and then we'll move on. Reply. We'll be talking about it, but just to allow it being structured, so just for you to fall in line with the particular framework. So what is a reply? Reply is a plaintiff's pleading in response to the statement of what? Of claim. So the plaintiff has made a statement of claim. The defendant has a defense. So the plaintiff's pleading response to the defendant's statement of defense is what? Is the reply. It's not automatic. You don't have to make a reply because we say there is what? There is a reply. So if you look at the Order 11 Rule 14, Order 11 Rule 14, and also Order 11, maybe we start right from Rule 4. Order 11 Rule 4. Order 11 Rule 4 makes the point that no pleading subsequent to a reply shall be filed except with the leave of what? The court. And we explained that to mean that all pleadings are matter of course under the law, so long as you are within the prescribed timeline. You don't need permission of the court to do any of those normal pleadings, isn't it? Statement of claim, defense, and reply. Statement of claim is served with it goes to the writ. You, the defendant, you enter appearance, you are supposed to file your defense within 14 days, generally speaking, unless special cases apply. After the defendant has filed the defense, the plaintiff has how many days to file a reply? How many days? How many days? Look at the law and tell me. What law are you basing yourself on? Order 11 Rule what? Order 11 Rule 3. A reply to any defense shall be filed by the plaintiff before expiration of 7 days after service on the plaintiff of that what? Defense. And we are told that you don't need to file a reply if you don't really have to do that. And that is why Order 11 Rule 14 would tell us that, in a sense, the purpose of reply is limited to answer new matters raised in the defense. So if the defendant has raised new matters, which your statement of claim did not actually speak to, then the reply is an opportunity for you to deal with that, isn't it? But for matters that you have talked about in your statement of claim, if the defendant, for example, says that they are not true, you don't have to worry because the trial is there, isn't it? But if the defendant said that what you have said, he denies that, and then he goes on to say some other things, and those things that he's saying are not any way captured or embodied in any of your pleadings in the statement of claim, then it makes sense for you to react specifically to those new things. So that is why we say that the purpose of reply is limited to answer new matters raised in the defense. And a lot of practitioners, sometimes they miss this point. And so pay attention to it. Reply, you have to study your statement of claim. When the defense comes, read your statement of claim again. Take your time and read the defense and ask yourself, is the defendant, apart from the defendant saying that he disagrees or he denies what I have said, is the defendant saying anything materially significant which I have not touched on in my statement of what claim, which I think that if I have my own version, which needs to be put as part of the case, so that during trial, I'll be able to leave evidence effectively on it. Then you do that. Again, reply is limited to respond to counterclaim, if any. So that is why I said that reply and defense. Reply and defense to what? Counterclaim. And we saw that the defense to counterclaim should accompany what the reply, isn't it? It should go together in the same document. Yes. Yes. Order 11, Rule 3. Yes. That's a counterclaim. Good. Yeah. You have more time. Yes, that's true. You have more time. Do you understand his point? Right. Okay, good.
Because the counterclaim is the same reply. The rule changes over there, the law changes over here, because false.
Yeah.
But there's no motivation.
Yes. Yeah, so if you understand him, if you look at the order 12, I think rule 3, with respect to defense to counterclaim, which we are told should be in the same document as the reply, isn't it? And we saw under order 11 rule, is it rule 3 or rule 2? Rule 3, that reply should be filed within how many days? 7 days. Good. So that's a general thing. But then, if you decide to, assuming the defendant made the counterclaim, the defendant made the counterclaim, and you decide to defend the counterclaim, which should be part of a reply, then it's 14 days. It's not 7 days. And that is true. If you are going to do reply and defense to counterclaim, then you have how many days? 14 days. But then he asked something about strategy of litigation as to whether because of the 14 days, you want more time. So you pretend to put in a defense. But you know that one is not automatic. You cannot do that unless there's a counterclaim to start with. If there's no counterclaim, you cannot pretend, you cannot defend that which is not there, isn't it? Yeah, so if there's a counterclaim, then you have 14 days. But if there's no counterclaim, you have to go with the 7 days. Again, reply is no opportunity to argue the statement of claim. So if you are just going to be using the same statement of claim to do the reply, there's no point, isn't it? You shouldn't do that. You shouldn't do that. And that is why we quoted Order 11 Rule 14 again. If there is no reply to the defense, there shall be a joinder of issue on that defense. And when you say joinder of issue, what does that mean? When we say there's a joinder of issue, what does that mean? When we say joinder of issue, what does that mean? Prefect Ophelia.
Issues arising or coming from the same case. Then we have different issues arising from the same case. Different issues arising from the same case being put together to avoid multiplicity.
Okay. Not necessarily. I know you are trying to use the joinder of causes of action and the joinder of parties to draw inspiration, isn't it? Not necessarily, but I want it to be a bit more. Yes. It simply means we disagree, isn't it? Because if I say there's a joinder of issue on this, what it means is that we have different positions. It will not be taken as agreement. So, Order 11 Rule 14.1, 2. No, sorry, 14.1. That if there's no reply, there shall be a joinder of issue on that what? On that defense. So, does it mean that because you haven't replied, you are taken as having admitted the defendant the defense? Have you admitted that it's correct? If it's correct, then you have lost the action, isn't it? Yes, so that is not the point. Then, and B, a party may in the party's pleading expressly join issue on the preceding pleading, and then there shall be no joinder of issue on the statement of claim or counterclaim. Now, let's look at the 14 Rule 4. A joinder of issue shall, and this is the meaning, So now, of course, you ask you to be reading. It means you are not reading. But if you are reading, you have had the answer already. So under 11-14-4, a joinder of issue shall operate as a denier of every material allegation of facts made in the pleading, unless, in the case of an express joinder of issue, any such allegation is accepted from the joinder and is stated to be admitted, in which case the express joinder of issue operates as a denier of every other such allegation. So, if you join issue trying to say that you disagree or you deny the material allegation the person is what is making, but it's possible for you to say that, okay, you admit this, but then you join issue on that. Save that so and so and so. The plaintiff joined issue on the paragraph so and so of this certificate of what? Of defense, or the defendant joins issue or whatever, as the case may be. But you cannot make it in general terms. You cannot simply just say that I join issue on statement of claim. Full stop. You finish your defense. Or the plaintiff cannot simply say that I join issue on the defendant's counterclaim. The reason being that we know from Hammond and Odoi, Daminadu, and so on, that pleadings are supposed to do what? To define the issue, narrow the area in controversy, isn't it? Yes. And give each other party or opponent the case that you should expect. So if you just did like a blanket denial, and you don't try to deny anything specific, or just, if you do general denial, are you saying that you are denying the plaintiff's name? No, so or your own name. Because don't forget that the plaintiff will have also, if you look at the statement of claim, the first 2 or 3 paragraphs is about explaining the identity of the parties and the resident occupation, isn't it? Yeah. And some of the things may even apply to you as a defendant. I've told you the story of the gentleman who was going to court, and then he has been prepared for cross-examination. So when he went, he had this thinking that the lawyer said that he should deny everything which would be said. So in the courtroom, sir, Yakoku Mensa, no. And then you are denying even his own name. Yeah, so where no reply is found, the plaintiff is deemed to have drawn issue on the defense. And if you look at the case of Ire Ashaliboche, Lance, Atta Wusu, and others against Pote and others, it's a case you should read in full, not only for this principle, for so many other things. You should read Abuso and Pote in full. 2003, 2004, 1 SCGLR 420. And the Supreme Court clarified that the failure to reply does not amount to admission of what? The defense. So if you look at the holding for example, the court said, quote, the failure of a party to file a formal reply to a statement of defense did not necessarily amount to an admission of the facts pleaded in the statement of defense. And consequently, it was also not fatal to a plaintiff case. A reply was not necessary, if its sole aim was to deny the facts alleged in the defense, or for, in its absence, there was an implied joinder of issues on the defense. So if all that you're going to say is that a plaintiff denies paragraph 4 of the statement of the defense, plaintiff traverse paragraph 6 of the statement of defense, that's all that deny, there's no point. then the law is giving you a default denial. And the default denial is that you are deemed to have joined issues with your opponent, isn't it? And that is why we said that you should use reply to react to new matters, which the defendant is setting up, which your statement of claim never talk about, as it were. And you think that because it's material, it may have bearing on the case that you are making. So a reply becomes necessary practically where the defense raises limitation. So if the defendant, for example, has set up a defense on limitation in the statement of defense, it's prudent to reply because limitation is not in vacuum. Limitation is premised upon certain material fact, isn't it? So it may be prudent for you to also set up a counter version or your own version of material fact, which does not support the defense of what? Limitation, or estoppel, set off, or illegality. If those things are in the defense, you need to do some reply. And as we've indicated, when new facts are introduced by the defendant in the statement of defense, you must reply. Otherwise, if they remain unanswered, they may prejudice your case. Now, if you don't reply in those situations, the plaintiff, you'll be deemed to have narrowed your case. Because if you don't agree, if you have other things, why is it that when the defendant said those things, you didn't also tell us? Yes.
But can a defendant depart from his defense, as in the case of the plaintiff? Because you spoke about raising new matters, which the plaintiff would necessarily have to reply. So I just want to know.
No, if I say new matters from the point of view of the plaintiff's statement of claim. The plaintiff's statement of claim, he has set out the basis of the reliefs, the claim that he's making. The defendant is supposed to just react to them. But in reacting to them by way of the statement of defense, the defendant, for example, may set up completely new matters which are not directly anticipated by the plaintiff in the statement of claim, in which case the plaintiff will need to reply, as it were. Or if the plaintiff is afraid of being accused of departure, he may have to do amendment and other system, as it were. But we'll be discussing amendment pretty soon. Maybe before we discuss amendment, let's discuss Order 11 rating, very important provision. Striking out pleadings. Let me give you 3 minutes because today you've consumed a lot of break time. So please, let's get up. We are not going up. Let's be on our feet. Let's be on our feet. Okay, so we're talking about striking out of pleadings before we had the break. So we have to look at Order 11 rating first. So we read Order 11 rating and then we discuss. Order 11 Rule 18, CI 47, quote, the court may at any stage of the proceedings, order any pleading or anything in any pleading to be struck out on the grounds that A, it discloses no reasonable cause of action or defense, or B, it is scandalous, frivolous, or vexatious, or C, it may prejudice embarrass or delay the fair trial of the action. Or D, it is otherwise an abuse of the process of the court and may order the action to be stayed or dismissed or judgment to be entered accordingly. Order 11 Rule 18.2, no evidence whatsoever shall be admissible on an application under sub rule 1A. So sub rule 1A talks about striking out on the ground that it discloses no reasonable cause of what? Action or defense. Now this rule it seeks to achieve two things. It tries to prevent defective pleadings and also cure it, as it were. It prevents waste of judicial time. Why? If the plaintiff does not have maintainable cause of action, with no cause of action now, the factual situation for which the law will give a remedy, isn't it? Litang and what? Upper good. So if we take the plaintiff's statement of claim and assuming they are true, they still do not support any relief in law. Why should you waste the time of the court and then the time of the defendant and say that no, let the plaintiff go through the trial, call his witnesses before we decide? When the whole case looks unsustainable at the very outset, looking at the plaintiff pleading. In the same vein, you look at the defendant defense, and it's just a sham. It does not really disclose any reasonable defense. And instead of the defendant just submitting to judgment, the defendant just wants to drag the matter. The defense can be strike out and the way will be cleared for the plaintiff to go through and get the necessary justice, as it were. Of course, it's also prevent harassment through frivolous litigation. Now, the power of the court to strike out and order, to strike out here defective pleadings or cause of action is in twofold. One is based upon the statute, as we've seen under 11 Rule 18. And two is based upon what we call the inherent jurisdiction of what? The court. A court of law, which has jurisdiction to adjudicate a matter, has inherent power in itself to ensure that its processes are not abused. So maybe if you look at the case of Akita against Republic Bank, Akita against Republic Bank, 2013-2015, 2JLL 824. If you look at the holding one from the editor's headnote, the point is made from the holding one that quote, an application under Order 11 Rule 18, the CI 47, might be filed and heard at any stage of proceedings, and therefore did not require a defendant to enter appearance before applying to have a writ strikeout for any of the reasons stated therein. However, an applicant may file a conditional appearance before applying to set aside a writ aside, even though same was not bound to file an appearance before filing an application. Now, in the case of Ahmed Mudi Adam against Frank Nuama, which is a very good case, because Justice Abadebe gave a good exposition on the matter. Ahmed Moody Adam against Frank Nuama, 2020-163, JMG Ghana Monthly Judgment, 211, I pay 224. But the same thing, if you have the 2017-2020 Supreme Court of Penal Report P36. But every JSC will, for example, make the point, he will cite from the Hospice Laws of England. So this is how you put it. Writing on striking out of pleadings, the learned authors of Hospice Laws of England, you quote the reference there, quote. However, the powers are permissive, not mandatory, and they confer a jurisdiction which the court will exercise in the light of all the circumstances concerning the offending pleading. The discretion is exercised by applying two fundamental, although complementary principles. What are they? The first principle is that the parties will not likely be driven from the seat of judgment. The parties will not be likely be driven from the seat of what? Judgment. And for this reason, the court will exercise a discretionary power with the greatest care and circumspection, and only in the clearest cases. So that's the first principle. We don't rush to drive a party from the judgment seat, preventing a party from having a say in what? In court. The second principle is that a stay or even a dismissal of proceedings may often be required by the very essence of justice to be done, so as to prevent parties being harassed and put to expense by frivolous, vexatious, or hopeless litigation, unquote. So sometimes the proceedings or the pleadings themselves may say that if you even don't strike it out or you don't stay the action, as the case may be, you're actually perpetrating what? Injustice. Or you're allowing the law to be used as an instrument of what? Injustice, as the case may be. Then what is an abuse of court processes? Read the case of Eastern Alloys Company Limited. Eastern Alloys Company Limited against Silver Star Auto Limited. 2017-2020, 1 SCGLR 611. Now, before we move on, this, if you look at the 18 or the 11 rating, it talks, among other things, about where there's a abuse of court proceedings or where the action is of vexatious. If you go to the Courts Act, the Courts Act at 459 has amended. There's a provision at the other section 100. Has anyone got the Courts Act here? There's a provision, I don't know, that's section 100, or there's a provision there which is about vexatious proceedings, where the Attorney General may go to court and ask the court to actually adjust somebody to be engaging in vexatious proceedings. For that matter, the person will be barred from bringing cases to court until the orders. You have it. What provision? No, let's get that first. I want them to confirm the provision. Section what? Section 74 of the Courts Act. Yeah, can you read it for us? Section 74 of the Courts Act at 459. I think the marginal notice is vexatious proceedings, or what does it say? Vexatious litigation.
Vexatious proceedings.
Vexatious proceedings. Okay, so read the provision for us. Section 74.
On an application by the Attorney General, the High Court may order that no legal proceeding shall be instituted by a person in any court without its leave, if the person has habitually and persistently, without reasonable ground, instituted vexatious legal proceedings in any court, whether against the same person or not.
Good. And that was why, in the case of Laboni Weavers Enterprise Limited, Laboni Weavers Enterprises Limited against Bank of Ghana, 1977, 2GLR, page 15, the court held that every person had an unimpeded access to the law courts of this country. And this basic and fundamental right could only be taken away by an express provision of a decree or an act of parliament, provided that act did not run counter to any provision of the constitution that the country might have. The only provision that could be employed to prevent a person from coming to vindicate his rights was the provisions of section 69 of the Court Act 1971 Act 372, which gave the Attorney General power to apply to the High Court to prevent a vexatious litigant from instituting an action in the courts without the leave of the High Court. So this section 69 of the Repeal Court Act 1971 is what has been reenacted as section 74 of the Court Act 1993 at 459. So just imagine somebody issue a writ against you. You went into the matter and the person had no case. Then the person goes and brings another writ against you. You will take up a point that this is res judicata. So it's actually dismissed, as it were. You bring another case. And you know that when a writ is served on you, the jurisdiction, which is expression of the sovereignty of the country, is being invoked against you. That is why we say that in the name of who? Look at the writ. In the name of, there's a command there. There's a command on the writ, isn't it? There's a command on the writ. Yes. So the person keeps on pestering you with series of suits, but all of them, they turn out to be unmeritorious. So that is a kind of vexatious litigant you are talking about. And if you are the victim, you could, for example, bring it to the attention of the Attorney General. And the Attorney General will come to court and say that due to XYZ, the Attorney General can even set up the various cases, which he has done as part of his evidence in the affidavit, to invite the court to say that due to XYZ, this person should be adjudged a vexatious litigant, and he should be barred from bringing any new case until the court grants him what? Leave. So that is what we are talking about. Yes.
The court on its own motion strike out, or it should always leave an application?
No, the court on its own motion can do that. And that is why we said that it even has inherent what? Inherent jurisdiction. Except that you ask yourself, at what stage does the court become aware? You see, people should have a practical appreciation of how things work in practice. When a case commences by the issue of the writ, pleadings and all that, the judge will be sitting in somewhere, as they put it in Ghanaian language, who will not even be aware of what is going on. All that is going on will be happening at the registry. You just go to the court registry, you pay the necessary filing files, you file them, a bailiff will go and serve, and so on and so forth. All this while, the judge has not come in. The judge is really not aware. And you don't even know which judge the case will be put before. It is when pleadings have closed, maybe there's a time for application for direction in case management, then it will be put before a judge. Or maybe there's an emotion. Maybe somebody requested for further and better particulars by letter, and then it was not heeded to. So you need to come by what? Motion that we put before the court. Or somebody is not able to effect service. So we need order for substituted what? Service. Then to come before the court. Other than that, the pleading stage is not known to the judge. So the judge on his own cannot just go and ask, go and bring me documents there for me to find out what. No. It will come before the judge for the first time. Apart from maybe those special applications like substituted service and so on. When we have application for direction, so during application for direction stage, the judge can tell them that having studied the pleadings, this and this and this and this should be strike out. Or you bring it to the attention of the parties, and then they may take some amendment measures, as it were. So that one can happen. And judges are actually supposed to do that, but oftentimes so trial judges will also inundate with a lot of work. So some of them, they don't pay too much attention to pleadings. They'll just allow the motion to be gone through. And the only time they'll give serious consideration to pleadings when they're writing their judgment. By which time, a lot of them who have the word, of course. There are a lot of, as I said, there are a lot of cases in this area, a lot of cases, and we need to deliver them. Please, I want you to look at the case of on this meaning of the frivolous suit and then a vexatious suit, abuse of power. Look at the case of Jacob Lamte against Gifty Lamte and 9 others. 2017, volume 112, GMJ 151. We can just get it in the galley. Is it Jacob Lamte and against a Gifty Lamte and 9 others. 2017, volume 112, that's volume 112, Ghana Monthly Judgment 155. You can also get it on Galley or Dennis Law or Judy Law or sometimes Ghana Law Finder, as the case may be. But you see, the order 11 rule 18 should not also be used lightly. And that is why we quoted the authors of a hospice laws, which Badebe used in his decision that we quoted, that a litigant or people should not be driven from the judgment seat. When people come to court, allow them to ventilate their grievances. Let's look into the merits, isn't it? And that is why, unless it's a deserving case, unless the case properly comes within disclosing no reasonable cause of what? Action. Meaning that, assuming you take the plaintiff's statement of claim, if we are to give the plaintiff the benefit of the doubt, let's assume what you have said. It's still allegation, but let's assume it is true. If it is true, based upon the law we know, in terms of the reliefs or the remedies we are looking, the nature of claim endorsed on the writ of summons, is this something that in law it can be granted you? Let's assume what you have said at this stage is what? Is true. Forget about what the defendant is saying. Let's assume what you said is what? is true, can we actually grant you the release you are looking for? And the nature of claim endorsed on the rate of 7 months. If the answer is no, then your rate does not disclose reasonable cause of what? Action, and you have to strike out, isn't it? In the same vein, with respect to the defendant defense, if we assume that what the defendant is saying is true, is it a complete answer to the claim of the plaintiff? Or is it like some sort of like an answer which would hurt the case of the plaintiff in a way? If the answer is no, then your defense is not reasonable, isn't it? And that is why in Commissioner Customs Excise and Preventive Service, or SEPS, against Mahogany Furniture Limited, 2001, 2002, 2JLR 476. Badebe J, as he then was the Court of Appeal, made this statement, quote, "I wish to sound a word of caution to those who desire to take points of law, commonly known as preliminary objections, which have effects, if properly taken, of disposing of actions without trial, by quoting the words of Evershed M.R. in Windsor Refrigerator Company against branch nominees, 1961, 1C8, 375 at page 396, quote, I repeat what I said at the beginning, that the course which this matter has taken, which this court has taken emphasis, as clearly as any case in my experience has emphasized, the extreme unwisdom, save in very exceptional cases, of adopting this procedure of preliminary issues. My experience has taught me, and this case emphasizes this teaching, that the shortest cut so attempted inevitably turns out to be the longest way around. Unquote. Order 18, Order 11, 18 is supposed to be shortcut, isn't it? In which case you end somebody's case, or you get somebody defense and thrown out. That is true. But as they say that the shortcuts are what? Dangerous. You do it, as I speak to you now, I'm not mentioning the region, but a certain appeal came from somewhere in the country. The High Court judge, just Order 11 18, the person brought an application that the rate should be dismissed for, no, like you said that I said that the statement of claim should be strike out for not disclosing the reasonable cause of what? Action. Then the judge, the defendant, the plaintiff filed the affidavit of opposition and so on, or during the hearing. The judge said, okay, he agrees with the plaintiff respondent that because the defendant has not yet filed statement of claim, it is premature for him to come under the 11-18. And for that matter, he did not even determine the merits of the application as whether the plaintiff statement of claim does not disclose reasonable cause of what? Action. And this matter is on appeal. So a civil procedure point, which was not taken serious, is right about what? An appeal. So I ask you, if you look at the 18, is it a requirement that if a defendant has not filed a statement of defense, he cannot invite the court to strike out the statement of claim for disclosing no reasonable cause of action? I ask you, look at it and tell me. Look at the law, don't rush. Yes. Are you with me?
Yeah.
Must. So if you look, must the defendant have filed a statement of defense before he will be qualified or he will be entitled to file an application pursuant to the Rule 18, asking the court to strike out, let's say, the plaintiff's statement of claim for disclosing no reasonable cause of action? Why do you say no?
So if you give us a case, Akita versus Republic, but and in that case, the court state indicates that the defendant does not even have filed the court from the 5 hours sector.
Okay, yes. Again,
Again, order 18 says that the court may at any stage of the proceedings order any pleading or anything in any pleading to be struck out on the grounds of the follow. So yes, you don't necessarily need to find if you can go.
okay, so repeat the point.
And also, I'm saying that order 18 reads, the court may at any stage of the proceedings order any plea or anything in any pleading to be struck out on the grounds that the follows. So I'm saying that it's at any stage. So stage 1 will be the writ and then the statement of claim. It's a stage. So the defendants will not necessarily have to file defense before an application is made for the pleading to be struck.
Yes. Yeah, that is it. So that was obviously a mistake, isn't it? So let's suppose that you are civil procedure examination. Assuming I was your examiner, which I'm not, thank God. You could be given maybe a brief narration. Let's say of what happened in this particular case. And let's assume that you're asked to either your research assistant to a judge or a panel or you're a lawyer for something, that's right. Then to be for you to be able to tell us your view, what was wrong with respect to what happened and what should have been like the proper one procedure, isn't it? But I would advise that in civil procedure, please, all the time, start from the rules. And that is why I want you to be familiar with the orders. Start from the statutory position first before case law. Don't let case law become superior to statutory position. Case law only expand or elaborate or contextualize. It helps us to understand how some of these rules actually work out. Or sometimes it helps us to understand their meaning. For example, when we say that frivolous action, abuse of court, or not disclosing reasonable cause of action, what does it mean? The statute itself will not explain it, isn't it? But based upon a court usage and all that, in the case law, we get the explanation. So, for example, like when it comes to somebody has a question whether the court on its own can strike out anything in the pleading. And then somebody has that question, isn't it? Yes. And of course, if you look at the law itself, it's possible or it's permissible, isn't it? And then when it comes to, let's say, the abuse of court process, as I said, the court has inherent the realization for that purpose. And if you go to like the old cases, even like our case, the Supreme Court, in the case of Benate and Glare, Benate is Jbenaartey, Benate and Glare is GLIE, against Netas Properties and Investments. Netas Properties and Investments. 2015 to 2016, 1 SCGLR C05 at 620. We look at that case, for example, the Supreme Court will have quoted a very old English case. They've quoted Lord Herschel in Lawrence and Lord Norris, 1890 decision of the House of Lords as follows, quote, "It cannot be doubted that the court has an inherent jurisdiction to dismiss an action. It is an abuse of the process of the court. It is a jurisdiction which ought to be very sparingly exercised, and only in very exceptional cases. I do not think that its exercise would be justified merely because the story told in the pleadings was highly improbable and one which was difficult to believe would be true. So, not disclosing reasonable cause of action does not mean that the story could not be true or whatever. No, that is not the point. And that is what Lord Herschel is reminding us. And that is why we said that if you assume what the plaintiff said, assuming that is the case, in law, does it support whatever he's looking for? Or if you assume what the defendant is saying, does it put up any F4 response to the plaintiff or the case, as it were? And again, in that same Supreme Court case, they also cited the English case of Wenlock and Moloney. In Wenlock and Moloney is a case you may want to read, very important. Wenlock, W-E-N-L-O-C-K, again Moloney, M-O-L-O-N-E-Y. 1965 to All England Law Report, 871 and 874. It's a decision of the English Court of Appeal, but they made a very important observation. Quote, Lord Justice Dankworth speaking, the practice under the former rule, RSC Order 25/4, and under the inherent jurisdiction of the court was well settled. Under the rule, it had to appear on the face of the plaintiff's pleading that the action could not succeed or was objectionable for some other reason. No evidence could be found, and I want us to pay attention to this. No evidence could be what? Could be found. In the case of the inherent power of the court to prevent abuse of its procedure by frivolous or vexatious proceedings or proceedings which was shown to be an abuse of the procedure of the court, an affidavit should be filed to show why the action was objectionable. But as the procedure was of a summary nature, the party was thought to be deprived of its right to have his case tried by a proper trial unless the matter was clear, unquote. So, Lord Justice Dankworth in Wenlock and Moloney were just reminding us of some fine distinction under Order 11 Rule 18. If you look at Order 11 Rule 18, we are told under Sub-Rule 2 that no evidence whatsoever shall be admissible on application under Sub-Rule 1A. Sub-Rule 1A says that when you are asking the court to strike out any pleading for not disclosing any reasonable cause of action or defense, isn't it? No defense. So you don't accompany with any affidavit. Just file the motion paper. Or the motion paper, the case, I mean the court, the forum, the title of the case, and then the heading of the motion. Motion or notice to strike out statement of claim or to strike out a paragraph, so and so and so and so, whatever, as the case may be. Or the 11 Rule 18. Then your motion paper, take notice. Or if you like the other style, motion or notice by Dr. Owusu, the counsel for on behalf of the plaintiff, no, counsel for on behalf of the defendant, praying the Honorable Court for an order to strike out paragraph so and so and so, or the entire statement of claim, as the case may be, for disclosing a reasonable cause of what? Action. the court shall be moved on so and so and so, then dash, notated that in Star Chambers, as a house, Kumasi. Yes. And then the court, your name, the license number, the chambers number, the registrar of the court, and copy for service on the defendant. You don't, so yeah, plaintiff, sorry, thank you. Copy for service on the plaintiff, thank you. You don't add any affidavit. If you add affidavit, it's wrong, isn't it? Because affidavit is what? It's evidence. But the rule says that no evidence whatsoever shall be what? Admissible. So assuming you are the plaintiff and you were served with that and then came with affidavit. Now when you go, you say that you raise preliminary objection. So on the day of the court, after you've introduced yourself, just as the counsel for defendant set up, you rise on your feet. Say, my lord, I have preliminary what? Objection. Stated. The application before the court is incompetent and it does not properly invoke jurisdiction of the court. I refer my lord to Order Rule 18, sub 2. My lord, if I may read, then you quote it. And then you just demonstrate it. But what is before us is the motion of notice accompanied by affidavit, which stands against the clear provision of Order Rule 18.2. And you sit down. Counsel for plaintiff, any reply? This one, what are you going to reply? This one, what are you going to? Or the one? No, you see, good. And this is where, or the one will not save you. It will not save you. Do you know why? No, or the one will not save you. Because, no, see, this is why you do interpretation in the course of time. If you have to do proper interpretation, or that one will not save you. Because that will defeat, then what is the point of having Order Rule 18.2? No evidence whatsoever. As even emphasis, didn't say no evidence shall be admissible. We said whatsoever. Isn't it? Just to let you know that whether affidavit or oral, no evidence whatsoever. So you cannot interpret Order 81 to say that because it's not, but no, that's not the kind of thing. Yes.
How then do you prove your case? I mean, once you apply for the motion to remove, it's not attached.
Oh, good.
So
Good. Yes. Yes. We are coming to that very soon. So categories of pleadings liable to strike out. 1, no reasonable cause of action to defend it. Order Rule 18, 1, which you are talking about. And that is why I said that a pleading disclosing no reasonable cause of action or defense, that is where assuming all facts pleaded are true. Assuming all facts pleaded are what? Are true. The law still affords no remedy. That is, the plaintiff cannot be given what he's looking for, or the law does not provide any defense to for the defendant as far as the plaintiff action is concerned. So in Okine Estates against Modern Science Limited, Okine Estate, and that's the case you must read, because you are what you call the manual. Okine Estates against Modern Science Limited, 1996-97, SCGLR 224. And the court will remind us that you not using evidence is a matter of what? It goes to jurisdiction. Invocation of the jurisdiction of the court. And you cannot do any other thing. So coming back to you, how will you prove, how will you make the case? You make your argument by demonstrating from the statement of claim. And that's, so you have to look at the writ, what reliefs is the plaintiff asking for. And then And then relief, don't forget, I also repeated the statement of claim, isn't it? If you look at the order 11, the statement of claim is supposed to repeat the reliefs. And that is why in recent time, a lot of authorities say that where there's even an error in the endorsement in the rate, it can be cured by the statement of claim because they are read together with their company word, each other. Good. So you try to make reference to where is Charles? Charles is missing today. Is Charles here? No, he knows Charles Sanchat. You have two Charles from Sanchat here. Sanchat. Staff. All right. All right. It's on leave. And apart from that, yeah, so we are now when it comes to the defense too, the plaintiff can also come and say that the defense should also be what? Strikeout, or pleading the defense should be strikeout for not disclosing the reasonable what? Defense, as it were. And that one too, there should be no affidavit. And you should also demonstrate from the pleadings so far. What about scandalous pleading? You know, apart from not disclosing reasonable cause of action, where it is also scandalous, frivolous or vexatious, that can also be strikeout, isn't it? And look at we've read the case of Ghana Muslim Representative Council against Salifu. Remember that? I'm sure you've read it by now. Have you read Ghana Muslim Representative against Salifu? You haven't read it. Who has not read it? So raise up your hands so that I will exempt you from what I'm going to do. Who has not read it? Just raise up your hand. Okay, I we have some others people here. 1, 2, 3. Okay, so some people listen to me. Ghana Muslim Representative was mentioned long ago when we were discussing which topic. What topic? Was it not joinder of parties? Yeah. So when the cases are mentioned, they are cosmetics, isn't it? They are not supposed to be read. Use them to decorate your nose. Okay. Yeah, yes.
With respect, with regards to my colleague's question.
Which one?
Concerning how you prove or you establish.
Without the affidavit. Sure, okay.
Can we consider the earlier case you made us read concerning Dr. Sanjona and Kulendi, where on the face of the pleadings,
yes,
it was said that Kulendi has actually been negligent, failed to protect the interests of the plaintiff. Now the court just the pleadings came to a conclusion that if you say someone has actually acted against your interests, for which you are bringing an action against, say a lawyer, you should first of all be able to establish that there is a lawyer-client relationship between yourself and the lawyer.
Yeah.
Now, if your pleading does not disclose such a relationship, you cannot come to say that there has been a breach of duty on the part of the lawyer. So just the absence of that connecting relationship between the plaintiff and Kulendi, the court said no. Then your so-called breach of duty action must fail or cannot actually go any further. So that's something I want to.
Yes, yeah, that's true. So just like let's say that they're running down action, you know, if you have the 3 elements, breach of duty of care, isn't it? is there a relationship where we can say that there's a duty of care? Or you read the writ and you say something like a vicarious, the person trying to make a vicarious claim, vicarious liability. But you read the statement of claim and you probably don't see anything which suggests that, assuming what the person is saying is true, it doesn't come out that we have like the employee-employer relationship. So assuming that is the only thing which is connecting the particular defendant, the defendant may probably go and say that this and that should be a strikeout because it doesn't disclose reasonable cause of action against me based upon, and just as he said, you don't make reference to any affidavit just by looking at the things in the pleadings, and then the court will be able to make the determination one or the other. The reason for not using evidence is that the whole point about this striking out, and as the authority says, is to have some kind of what they call like an abridged procedure, a shortcut to end the case or to end somebody's defense. And if that is so, then trial is not necessary. And when you talk about trial is by evidence. Evidence is by either affidavit or evidence which is received in the witness box, isn't it? And that is why evidence is not supposed to be what? Taken. If evidence is to be taken, then you defeated the purpose. That means there's something to look into. There's a tribal, as it were. Then why do you have to say that it doesn't disclose anything? I said you should read Ghana Muslim Representative, please read it. And that if you look at the holding 4 of that case, for example, the court stated it was a matter within the judicial discretion of a judge whether or not to strike out pleadings or stay proceedings on the ground that the pleading disclosed no reasonable cause of action, or defense, or that the action had no reasonable chance of success. The jurisdiction of the court must, however, be exercised with extreme caution. A pleading will only be struck out where it was apparent that even if the facts were proved, the plaintiff was not entitled to the relief he sought. In any case, affidavit evidence was inadmissible on applicating to strike out pleadings on the ground that the plaintiff had no reasonable chance of success. And similarly, I ask you to read the Hydrafoam Estates and the modern science. It's a case you should read in full because it has a lot to teach you with respect to what we are discussing. So what happened in that case? In the Hydrafoam Estates against modern science, the plaintiff, applicant, and the defendant respondents traced their root of title to a piece of land at somewhere in Owusu, Niman Estates, who Ni Odoi Kwao, family of Owusu. Both parties, that is the plaintiff and the defendant, had documents on the land, which have been registered under Act 122. But in addition, the respondent had a land title certificate under PNS Law 152. So the applicant, in this case the plaintiff, claiming to be the rightful owner, brought an application. I want you to pay attention to the procedure aspect here, so listen well. Brought an application before the High Court, Accra, against the respondent, defendant, for a declaration of title, ratification of the land register, and cancellation of the respondent's land certificate on the ground that they have been procured by fraud or mistake and in breach of provisions of PNS Law 152, that is the land title registration law, which has been repealed. The applicant also sought the cancellation of a deed of assignment from the first respondent to the second respondent In their defense, the respondent contended that at the time of the purported conveyance of the plot to the applicant's predecessor in title by the Knock family, the family had already divested its interest title in the land and given same to the respondent predecessor in title. And thus the applicant had no title to the land. The further contended that in the circumstances, the document the applicant was relying on did not confer title to the land in him. Subsequently, the respondent brought an application, and this is what is of interest to us. Subsequently, the respondent, that is, brought an application to dismiss the plaintiff's suit. So the respondent here, the defendant, they brought an application to dismiss the applicant's suit for non-disclosure of cause of what? Action, on the ground that as a result of the prior grant to their predecessor in title and their prior registration of their title document, their title to the land had priority over that of the applicant. The applicant opposed the application on the grounds entirely that the pleadings disclosed tribal issues between the parties. As such, Atlantis Commission disclosed no recorded transaction between the Knock family and the respondent predecessor in title, and besides, the alleged grant by the respondent's predecessor entitled the first respondent was a forgery. The trial judge, after considering the affidavits and exhibits filed by the parties, so here, affidavits were filed. Meanwhile, the substance of the application was seeking, striking now for disclosing no what? Cause of action. So the trial judge, after this, considering affidavit and exhibit filed by the parties, however, held that the land certificate of the respondent conferred indefeasible title to the land in them, and therefore no useful purpose to be served by allowing evidence to be adduced by the parties. Accordingly, he admits the applicant's action in exercise of its inherent jurisdiction and gave judgment for the respondents. Agreed by that decision, the applicant then brought an application before the Supreme Court for an order of certiorari to quash the judgment of the High Court on the grounds of breach of rules of natural justice, lack of jurisdiction, and error of law in the face of the record, and a further order for the suit to be relisted before the High Court to proceed to trial in the normal course. In support of the application, the applicant contended that there was an apparent error of law in the face of the record, because although the respondent had brought the application under 25 reform, the High Court under 25 reform is a equivalent of under 11 what? Waiting. The High Court had erroneously proceeded under its inherent jurisdiction and admitted and relied on affidavits and extrinsic evidence in the form of exhibits. So this order 24 reform is under the LN 140 what? A, the old civil procedure rule. So if you look at the table of, there's what, please look at your law. There's what you call the table of equivalence. Everybody look at it. So that when you're practicing, you come across, you know what to do. There's a table at the beginning, we call the comparative table. The comparative table, that's the starting. We have the title, High Court Civil Procedure Rules 1954, High Court Civil Procedure 2004, okay? So the idea is to do what we call the matching equivalence. It will be reenacted. So we are dealing with the 11, isn't it? And the CR 47. Let's find out the equivalent of the 11 under the old law. Is what? For the 11 was 19. Okay. Okay. Good. So, okay, 25 was the proceedings in lieu of the demurrer. Okay, good. Look at it. So if you look at the order 11 and the CI 47, have you seen something? Order 11, it comes twice. It's a reenactment of order 19. An aspect of current order 11 used to be what we call order 25. So the things we're talking about under order 11 rule 8 will be part of order 25 under LN 140. So that is the point it's showing us. But let's continue to our case. So the High Court had erroneously proceeded under its inherent jurisdiction and admitted and relied on affidavit and extrinsic evidence in the form of exhibits. The respondent, however, opposed the application and also raised a preliminary objection to it on the grounds that when I ask you to read the case, you not read. If I want to read in portion of it for you, not listen. What should I do now? On the grounds that, one, the title of the applicant's application, quote, Hydrafoam Estates Ltd. versus Modern Science Limited and another, was contrary to the approved practice and therefore wrong. It should have read Republic against Additional High Court Judge, expert Modern Science Limited. Two, since the High Court had jurisdiction over the matter, the appropriate remedy for the applicant was an appeal, not certiorari. And three, since the applicant did not file a statement of case with the notice of motion, the application was contrary to the approved practice and so on. Those are not important. Those are the Supreme Court practice rules. Now, the holding, holding one, where there was specific rules of procedure, they had to comply with. Since it's talking about the procedure for filing statement of case and all that, so that one is so important for you now. Let's move on to what we are discussing. That is the striking out. Yeah, so that is a holding 4. The purpose of Order 25-4 of LN 148, which is equivalent of account of the levy reward 18, was the prevention of claims which on the face of the pleadings disclosed no cause of action or which was shown to be frivolous or vexatious. However, under the inherent jurisdiction of the court, the purpose was to give the court summary means to prevent abuse of its processes. Accordingly, under Order 25-4 of LN 148, only the pleadings might be considered by the court. But under the inherent jurisdiction, the court might take into account affidavits and extrinsic evidence. So mind you, two things are happening. The court is saying that if you are coming under levy rule 8, then we are for the new one, or the levy rule 18, is it 1A? Yes. Then we are told that no affidavit, isn't it? But if you are coming under maybe C and so on, that is abuse. You know, abuse or scandalous or frivolous. B, yes. Affidavit will be entertained. And here, it is not only the statute, there's also inherent what? Jurisdiction. Also inherent jurisdiction of the court. When it comes to inherent jurisdiction of the court can look at what? Affidavit. So that is why the striking of disclosing a reasonable cause of action is a very specific one. But let's continue. Given the clear differences in the established practices and procedures of the two remedies, they could not be considered to be interchangeable or simultaneous unless they were both specifically applied for. Consequently, in the instant case, since the respondent notice of motion before the High Court did not disclose the rule or procedure under which the application was made, the court should have first ascertained which of its powers was being invoked, and therefore which procedure was to be applied. The most practical manner for the properly applicable practice would be to examine the specific words used in formulating the grounds for the application. Since the respondent application was to dismiss, so quote, to dismiss the suit for non-disclosure of cause of action. So that's what they use, to dismiss the suit for non-disclosure of what? Cause of action. But did not ask the court to dismiss the action for being an abuse of the process of court. And furthermore, in the supporting affidavit, an abuse of process was neither alleged nor shown. It was apparent on the face of the application that it was made under Order 25-4, LN 148, which is equivalent Order Levy Rule 18-1 A of CI 47. In the circumstances, the fact that the application used the words dismiss the suit rather than strike out the pleadings was irrelevant. Accordingly, the High Court erred in taking extrinsic evidence into account. Accordingly, there was error of law apparent on the face of the record. So, the court was saying that in this particular application, the applicant, the defendant, in bringing the application to have the matter, they say to dismiss for not disclosing what cause of action, did not indicate on the face of the motion paper whether it was pursuant to Order 25 Rule 4, LN 140, which is equivalent of Order 11 Rule 18 1A, on the one hand, or it did not say that it was bringing it under the inherent jurisdiction of what? Of the court. And in the court's view, if it had even been just the inherent jurisdiction of the court, then the court could entertain affidavit. But that one, it will be like abuse. The inherent jurisdiction relates to the abuse. When it comes to abuse of court, the court has inherent what? Jurisdiction. So it doesn't matter if you don't come under the review rating. But that one, the court can look at affidavit. But then the court said that in this particular situation, because there was that omission, what the High Court ought to have done was to examine the wording of the prayers which the applicant was seeking the application and the affidavit file. And when they examined, although they didn't use the magical words, striking out the pleadings, but so like dismissing the suit for not disclosing the cause of what action, the Supreme Court was the view that so far as there was nothing in the affidavit to show that the applicant was even thinking of abuse of court, then certainly it was not about abuse of court which was being complained of, in which case the inherent jurisdiction of the court would have been what? Applicable. So since we are not talking about abuse of court, it means you were actually talking about striking out or pleading for disclosing no reasonable cause of action, despite the fact that you failed to use the word striking out and rather use the wrong word, dismiss. And for that reason, the court should not have entertained the application so long as it had affidavit or evidence, and then should have just dealt with as it was. So if we look at the holding 6, on the face of the materials presented, in addition to the issue of title, very serious allegations of fraud have been made against the respondent and full particulars have been given. However, whether there was fraud or not depended on the facts of the case and could only be ascertained after the defense had been filed and the court had given the parties requisite opportunity to be heard on the issue. A denial of an allegation of fraud raised a tribal issue, which a court could not determine summarily. In the circumstances, the summary way in which the High Court erroneously dismissed the case, denied the applicant a hearing, a denial which amounted to a violation of a fundamental rule of natural justice. Accordingly, in the exercise of the Supreme Court's powers that the 1992 Constitution, judgment of the High Court will be set aside, and the case sent to the High Court for pleadings to take their normal course. So please read Okufu's against what? Modern science. Also read the case of Harriet Morrison. Harriet Morrison and Charles Cantamanto. Harriet Morrison and Charles Cantamanto Bar Jr. against registered trustees, Victory Bible Church. You have church members here? Victory Bible. Against registered trustee, Victory Bible Church. 2015. JELL. That is my case is from the Judy Law. That's the database. I can also get it from the other sources. I want you to read the majority decision and dissenting decision of Justice Jose Doche in that particular case. Yes. And I think I've also mentioned the case of Ahmed Moody Adam against Frank Nuama, isn't it?
Yes.
Good. So read that as well. Ahmed Mudi Adam against Frank Nuama, 2020 decision. Good. So let's have a close of pleadings. Under Odalabi Rule 19, Rule 19, pleadings close 7 days after the service of the last pleading. I hope we are all aware of that by now. Odalabi Rule 19 of CF 47. Yeah, the pleadings and action are closed. A, at the expiration of 7 days after service of the reply, or if there is no reply, but only a defense to counterclaim, after service of the defense to counterclaim. So here you see the issue that we confronted. If there is a reply, 7 days after the service of what? Reply, pleadings are what? Are closed, isn't it? Is that what it says? Good. And then if there is no reply, but only defense to counterclaim after service of what? The defense to the counterclaim. But still 7 days. Mind you, the 7 days also apply. 19(1)(b), if neither a reply nor a defense to counterclaim is served at the expiration of 7 days after service of the defense. So where the defendant made no counterclaim, or if there's a counterclaim, the plaintiff elected not to file a defense with counterclaim, and also elected not to have a reply, then 7 days after the service of the defense, the pleadings are deemed to have been what? Closed. Now, why is that important? Now, Odalabi Rule 19 provide certainty. The reason being that litigation cannot remain perpetually fluid. Mind you, pleadings about the paper battle, isn't it? There should be an end. There should be a point where we know that we have finished defining our contrasting position, isn't it? Yes. So once pleadings are closed, the issues are crystallized. We know the points of disagreement where we need to direct the trial. And no new issue will be admitted without what? Amendments. And two, once pleadings are closed, discovery becomes automatic. Discovery becomes automatic. What do you mean by discovery? That is, the parties must disclose relevant documents. Now, we have set out our respective cases per the pleadings. Now, there's nothing to hide. I have told you what you should expect, isn't it? Good. So, based upon my pleadings, what documents do I have in my arsenal which I'm going to use to prosecute my fight against you? I should make them available, or if you request to inspect or something like that. And later on, we discuss that. You notice that discoveries, interrogatories, and then the admissions, these are meant to actually expedite resolution of the dispute. Sometimes, if your opponent sees that you have a particular document there, and then the opponent is so satisfied that there is no problem about authenticity, and that particular document holds the key, it's a golden key to what you are fighting about. Why will you waste your time to continue when you know that ultimately this will be the outcome? It can even help you to sometimes to either even settle or explore some ideal, isn't it? So once pleadings are closed, the case also becomes ripe for directions. The case becomes ripe for what? Directions. So trial management begins. So directions, we'll discuss it pretty soon. That is where the parties, together with the court, will say that, okay, based upon these pleadings, these are the questions which need to be answered. Either questions of law or questions of what? Facts, which need to be answered. And then the trial is going to be guided by that compass. Then finally, once pleadings are closed, what it means is that evidence to be adduced at the trial is confined. Because as we have seen, evidence must support pleaded facts, not the other way around, isn't it? You must have the pleaded facts, and that should invite the evidence. And if you look at the case of Ire Ashalboche Lance, you cited it already, 2003-2004, 1 SCGLR 420. The Supreme Court effectively made the point that close of pleadings must transition from formulation to what? Adjudication. You are formulating a controversy. When pleadings are closed, then it's right for adjudication, for trial. Now, just before we end the day, we want to introduce amendment of pleadings. Amendment of pleadings. Yes. So let's go to order 16. Don't worry, we'll come back and discuss summary judgment and then the third party notice. I want us to finish everything about pleadings. That is why we are going to order 16. So, amendment of pleadings. First and foremost, amendment exists as an antidote to technical injustice. Human beings, we are fallible, we make mistakes, isn't it? Litigation is a human activity. Just as human beings, we are not perfect. It reflects in all the things that we do, including when we are pleading our cases. And pleadings are drafted under pressure. Lawyers are sometimes very much in hurry. So mistakes are what? Inevitable. They are bound to occur. And for that matter, if you read Mr. Kwame Tete's book, he will make the point that amendment reflects the philosophy that justice should not be sacrificed on the altar of form. Justice should not be sacrificed on the altar of what? Form. Because somebody has made some mistakes relating to form but not substance, and the person is going to lose out on something. So if you look at order 16, you notice that, first of all, it allows amendment at any stage. And that's very important. It allows amendment at what? At any stage. On such terms as the court thinks just, as it were. And the court has a broad discretion, and it's for good reason. It allows the court to tailor justice according to the context. There's a particular case which I given a judgment yesterday, but when we went, there was no proof of service, so we adjourned it. But it's very important on amendment. When it comes out, I will let all of you read it. And the point being made is that, yes, the court has a discretion when amendments applications are brought. But it's not enough, for example, for you to say that maybe I have heard the parties, I've read the affidavit. I don't think that the application merits favorable exercise of my discretion. The application is what? Refuse. It's not enough because you need to demonstrate from the proposed amendment, maybe vis-a-vis the current pleadings or whatever the state of the trial is, and then justify why you think that it's not appropriate for discretion to be exercised for the amendment to be allowed or not, as the case may be. So if we agree that you read order 16, so should I assume that you learn amendment on your own? And then we move on to something else. Then if you don't mind, I know you mind. Give me just 15 minutes to finish. Just 15 minutes and then. Okay, since you are opposing me, I will end.